The second dose, I guess I felt sort of out of it for a day, but my daughter got really sick on the second dose of Pfizer, but they say younger people uh, have more problems than older people.
Interesting. You'd think it'd be the other way, right?
Right, yeah.
These younger people are better with like COVID itself as opposed to older people. Younger
Yeah.
people have fresh reactions to the shot. Yeah. Good morning.
Morning, Judge.
Good morning, everyone. Connie, can we go on the record, please? Connie, are you there?
You hear me?
Yes.
Okay.
Can we go on the record?
Yes.
Okay, thank you. Good morning, everyone. Today is May 6th, 2021. It's 10 o'clock in the morning. We're here for Public Service Commission case number 9614, which is captioned in the matter of the complaint of the staff of the Public Service Commission against Direct Energy Services, LLC. My name is Jennifer Grace. I'm the Public Utility Law Judge assigned to handle this matter. Oh, good morning, everyone. We can start with appearances. Mr. Green.
Morning, Your Honor. I'm Brian Green with the law firm Green Herlocker, and with me today is Eric Wallace, and together we represent Direct Energy Services.
Good morning. Office of People's Counsel.
Good morning, Your Honor. This is Philip Sheehan. I'm here on behalf of the Office of People's Counsel.
Good morning, Mr. Sheehan. And staff.
Morning, Your Honor. I'm Catherine McErlane, Assistant Staff Counsel. On behalf of staff and also representing staff counsel this morning is Mr. Peter A. Wilson.
Good morning to both of you. So we have several things that we need to enter into the record. I'm not sure who wants to go forward with that. Perhaps Mr. Green?
Sure, I'll let staff introduce the settlement agreement and the joint motion, and I'll start off with the Direct Energy exhibits, if that's okay.
Yes.
Okay. So we have 3 exhibits, Your Honor. The exhibit number 1 for Direct Energy is the rebuttal testimony of Frank Lacey. It was pre-filed on March 19, 2021. It consists of 147 pages, 23 exhibits, and 9 appendices. There is a public and confidential version, so I would ask that that be marked and entered as exhibits 1 and 1C. Then
I'm sorry, any objection? Hearing none, direct exhibits 1 and 1C are marked and admitted.
Exhibit 2 and I guess 2C will be the April 9th, 2021 pre-filed surrebuttal testimony of Frank Lacey on behalf of Direct Energy. It consists of 9 pages and 1 exhibit. And I'd ask that it be marked and entered as 2 and 2C.
Any objection? Hearing none, direct energy exhibits 2 and 2C are admitted.
And Direct Energy Exhibit 3 would be the May 5th pre-filed testimony in support of the settlement agreement by Frank Lacey. It consists of 5 pages and there is only a public version. It has to be marked in Exhibit 3.
Any objection to a direct energy exhibit 3? Hearing none, direct energy exhibit 3 is admitted.
That is all.
Thank you. Office of People's Counsel.
Good morning, Your Honor. We would like to admit into evidence the testimony of Susan Baldwin dated May 5th in support. Testimony of Susan Baldwin on behalf of the Maryland Office of People's Counsel in support of the proposed partial settlement. And it consists of a cover page, 4.5 pages of narrative evidence and no exhibits. And we would also like to admit the direct, supplementary direct, rebuttal, and surrebuttal testimony of Susan Baldwin. And I apologize, I only have one screen. I can't give you the dates or number of pages, but it's all been filed with the court. And there's a confidential version of the direct testimony. The supplemental direct testimony, I don't think, I think it did include a partial confidential version. Rebuttal and surrebuttal, I do not think there was a confidential version, just the public version.
So let's go ahead and mark OPC Exhibit 1 will be the 1 and 1C will be the direct and confidential direct. Sorry, I know these mics are directional. OPC Exhibit 2 will be supplemental direct. OPC Exhibit 2C will be the confidential version of the supplemental direct. OPC Exhibit 3 will be rebuttal. OPC Exhibit 4 will be surrebuttal. And OPC Exhibit 5 will be the testimony in support of the settlement. Are there any objections to those exhibits? Hearing none, OPC Exhibits 1 through 5, including 1C and 2C, are admitted.
Thank you, Your Honor.
And staff.
Good morning, Your Honor. The parties have agreed to stipulate to the direct testimony of staff witness Kevin D. Mosier, ML 228966, filed on behalf of the staff of the Maryland Public Service Commission, dated March 6, 2020, consisting of 14 pages with confidential exhibits. I would like to have the direct testimony marked for identification as Staff Exhibit 1 and 1C.
So marked.
The parties have agreed to stipulate to the testimony in support of settlement of staff witness Kevin D. Mosier, ML 235139, filed on behalf of the State of the Maryland Public Service Commission, dated May 5th, 2021, consisting of 4 pages. I would like to have a testimony in support of the settlement of staff witness Kevin D. Mosier marked for identification as staff exhibit number 2, please.
It is so marked.
The parties have agreed to stipulate to the Direct Energy joint application for approval of settlement ML number 235048, filed on behalf of the Maryland Public Service Commission, the Office of People's Counsel, and Direct Energy Services, LLC, dated April 29th, 2021, consisting of 8 pages. Your Honor, I'd like to have the Direct Energy joint application for approval of settlement marked for identification as staff exhibit number 3, please.
It is so marked.
The parties have agreed to stipulate to the Direct Energy partial settlement agreement, including attachment 1, ML number 235048, filed on behalf of the Maryland Public Service Commission, the Office of People's Counsel, and Direct Energy Services, LLC, dated April 29th, 2021, consisting of 7 pages and 1 attachment consisting of 17 pages. Your Honor, I'd like to have the Direct Energy partial settlement agreement marked for identification as staff exhibit number 3A, please.
Give me 1 moment, please. Staff Exhibit 4 with attachment is marked.
Taken together, these documents constitute staff's pre-filed testimony and the parties' stipulated testimony in this proceeding. Your Honor, I'd like to move staff exhibit 1, 2, 3, and 4 into the administrative record of this proceeding, please.
Any objection to 1, 1C, 2, 3, and 4? Hearing
I have an
none.
objection, Your Honor. Or it might be just the need for clarification, but OPC is not stipulating to anything other than the testimony in support of the partial settlement, the joint motion, and the actual settlement agreement. And we reserve the right to cross-examine at a later date testimony that relates to the NHTSA issues.
Okay, so the partial objection or clarification is regarding staff 1 and 1C, the direct testimony of Mr. Mosier,
Correct.
or the attachment to the settlement agreement.
No, we stipulate to the settlement agreement and the attachment to the settlement agreement.
Okay,
But with respect to testimony of other parties, witnesses, other than testimony in support of this settlement, we reserve the right to cross-examine those witnesses when the NHTSA hearing occurs.
okay, I understand. Staff exhibits 1 through 4 are admitted.
Your Honor.
All right, I have some questions just for counsel, not for witnesses. I know witnesses have been waived for today regarding the settlement. I guess let's begin with the Maryland Telephone Solicitations Act, which we'll just call MTSA, MTSA for the court reporter. So the settlement at which is now staff 4 at page 3, paragraph 4C. The settling parties reserve the right to argue the appropriate remedy applicable to any violation related to the MTSA issues. The agreement, the partial settlement agreement before me right now calls for a fine and a refund, which we're calling a re-rate, which I'll ask about in a minute. Are there any limitations as to what the parties have discussed regarding paragraph 4C? Is it possible that one of the parties may, at the next phase of this hearing, when we're addressing the MTSA issues, be asking for more either civil penalties or refunds with regards to those issues?
OPC believes that that is the case.
And staff believes that's the case as well.
Right.
Okay.
And I will add that the idea under 4C was that if there is a violation of the MTSA issues found at a later date, then all parties would argue about the severity of those violations and what is the appropriate penalty, if any. And so we just, in addition to carving out the issues, we carved out any potential penalty related to those issues as well.
Okay, with regards to the issue carve out, have the parties made any correlation between the issues contained in the partial settlement agreement under 4B and the specific complaints made by both staff and the Office of People's Counsel in the complaint, the amended complaint, etc.?
I'll take a stab at that and everyone can chime in, but to the extent there was testimony from the witnesses, mostly Mr. Lacey, Ms. Baldwin, and Mr. Mosier, that dove into the CAD complaints and compared which ones were telephone enrollments, which ones were door-to-door, and of the telephone enrollments, which ones were the result of outbound versus inbound calls. There's a lot of testimony about that, but we have not gone the next step and discussed among the parties where violations may or may not have occurred outside of the testimony that's been submitted. I hope that answers your question.
Yes. Are all of the parties in agreement that the remaining MTSA issue is a legal issue? Are there factual agreements between the parties regarding those CAD complaints?
OPC believes that there are factual issues. I mean, it's primarily a legal issue, but with respect to qualifying for exemptions from MTSA, the mailings have to be examined, and then if it's determined that MTSA doesn't apply, then there may be some factual issues related to the COMAR requirements for contracting.
it was staff's belief, and I think all the parties, they agree there are some factual issues, but have agreed to work on stipulating. Hopefully, at some point, we can arrive with, get to a point where we just have legal issues that we can submit. If not, we'll have to have an actual evidentiary hearing. But
Is-
it was our intent to try to arrive and resolve all the factual issues so that this can be dealt with as a legal matter only.
Is the party's intention with the Mitza carve out to delay that portion of the case until any and all appeals on other matters are completed, or is that something that we would be able to go forward with in upcoming months?
Your Honor,
PSC contemplated that it could go forward at any time you deemed appropriate.
Okay.
right, and I think we had, Direct Energy had contemplated that as well. The problem, of course, is that based on what we might find in the Court of Appeals, I should say, in the appeal process, things could change as to this case and even other pending cases, show cause cases at the commission. And that what we're a little hesitant about from Direct Energy's perspective is having this case proceed on the MTSA issues to ultimately a proposed order and a final decision, what will likely be, right, if we don't have appellate guidance on another case, that will be an appeal to the full commission, as in this case, right, on a proposed order here, and then ultimately an appeal decision comes down in the other case from the courts that changes this case. So we're trying to. I'm not saying don't go forward here. I'm just saying that is a potential real problem that we may have to deal with down the road, and I'm not sure what the best way to deal with it is. I think because it could be years before the other case is resolved as it works its way through the court system.
Absolutely. And that's what the question was going towards. I don't want to delay essentially, I guess, what might be a phase 2 in this case for years before we get started. So I just
Your Honor,
wanted some
can I
guidance from
say,
parties. Go ahead.
can I add a bit of information? When we started the mediation process with Judge Lawrence, the idea of separating and delaying the MITSA part was because we were waiting for the decision from the commission. And then during this process, the commission issued their decision, and petition for judicial review was filed in Montgomery County. And I mean, I guess that was always contemplated, could be appealed, but we were really thinking about getting guidance from the commission.
Okay.
And Your Honor, if I may just agree with what Mr. Wilson said about legal versus factual issues here, I think I agree with OPC also that they are primarily legal issues on the MTSA issues. There are some factual issues, such as if we're going to have a discussion on the MTSA issues about mailings, then we have to enter the mailings into the record, right? So we attached mailings to the settlement agreement, but we would envision that the stipulation would include these were the mailings, and these were the number of inbound enrollments, and these are the number of outbound enrollments, and and facts like that where everyone could point to and be able to decide the 3 issues. And for example, if the MTSA does not apply, and we get to 4B3 and we have to determine did Direct Energy comply with the applicable COMARs when the MTSA does not apply, we would hope that we could have facts in the stipulation of how Direct Energy enrolled customers when they didn't get a signature, for example, so that it would comply, or we could make everyone could argue about whether that process complied with the applicable COMARs. So there are some factual components, but I would agree with Mr. Wilson that, and hopefully Mr. Sheehan, that those are things that could be covered in stipulations.
So thank you. I have to compliment the parties. There was a lot of paperwork in this case, and you all worked very well together to get to where we are today. And I have faith that you will continue to work together on the MTSA issues going forward. I think what I'd like to do is set a date, and I'll get some guidance from you all with how busy your schedules are, for a filing to be made, which would include a suggested procedural schedule for well, I'm just calling it for right now, the second phase of this hearing, the MTSA issues. And with that, a stipulation of fact as best as you can, stating the issues that are remaining for that portion of the hearing. I don't know how long it might take for you all to get together to do that. I know there are other cases pending that involve most of the same parties. So think about that, and we'll return to that at the end of this hearing. I do have some questions about the customer refund, which we're calling a re-rate. Can you, Mr. Green, can you explain that a little bit and explain the calculation, please?
Sure. So my recollection on the 21 is those are 21 CAD complaints where there were slamming allegations, and they were identified by Ms. Baldwin in her, I can't remember which testimony it was, but in her testimony. So the agreement is that Direct Energy will go back and look at those 21 complaints, and regardless of the outcome of those complaints, Direct Energy has agreed to calculate re-rates or refunds, and the difference, the amount of the refund is the difference between what the customer paid to Direct during the time they were enrolled, minus the SOS or sales service rate, minus any refunds that have already been paid. So they've already started, the company has started looking at which of those 21 have already received re-rates in order to be able to make that calculation, and also what the SOS and sales service rate is. And we'll, as pursuant to the settlement agreement, we'll be working with OPC and staff going forward on those re-rates and the notices to the customers.
So it's an individual calculation for each customer based on the rates they were paying and the SOS rates for the time period. Is that an every month
Yes.
calculation? Okay.
Yes, these were customers that enrolled during the complaint period. So prior to May 2019, and now I'm blanking on when the complaint period started, but and then regardless of how long, for their lifetime of being a customer of Direct Energy, we would calculate a month-to-month amount, and then they would get whatever that totals, they would get a check for that. Less whatever we might have already paid them.
Your Honor, it's actually like a monthly snapshot for the entire length of their enrollment that looks at what they were paying Direct Energy, and if that changes, the calculation changes, and also SOS changes, as we all know. So that has to be changed, month to month.
Do you have an idea of when that calculation will be completed?
I was hoping I'd have it today because I had a feeling you'd be asking. So I don't. I would expect to have it. I don't know. I don't know what the holdup is. So I can certainly ask and provide that calculation to everyone as soon as I have it.
So by way of bench data request 1, I'd like a copy of
Mhm.
that calculation when it's complete.
Sure. And they may spill into next week, Your Honor, but I will certainly get word that we need to get that finalized.
It's fine. So going forward, I would need to get an order out on the settlement, but we also need to go forward on the MTSA portion of this hearing. If we're looking out to, today's May 6th, so if we're looking out to like the end of June, would that be a good time frame for the parties to submit a, we can either do it by way of a scheduling hearing, or I could just ask the parties to submit a suggested procedure for this case, and with that, more stipulations of fact as to the specific, I guess, breadth of the next phase. I'm looking towards seeing if we can get agreements on most of the factual issues so that we can proceed just with briefs.
That would be our goal also.
So end of June, is that an appropriate, is that feasible for the parties?
Your Honor, for OPC, it would actually be better if it were just after the the week after the 4th of July holiday.
Okay.
And not to be negative, but I don't see how we're going to be able to stipulate. We're never going to stipulate that each and every mailing complied with the requirements necessary for the MITSA exemption. So,
Oh, we're not. I wouldn't expect that would be a stipulation. I'm sorry to interrupt. I'm sorry. Go ahead.
Go ahead. No, go ahead.
I wouldn't
No, I
expect
think
that would be a stipulation. The stipulation would be, here's the mailing
right.
attached as exhibit 1 or whatever. And then everyone could argue based on the content of the mailing whether it had a description of the goods and services sufficient to satisfy that particular provision of the or the toll-free number, or the other requirements of to be able to satisfy the exemption. But I wouldn't expect anyone to stipulate whether something complied with the statute or not. That's for briefing.
Let's do this. Let's set a date for a mutual filing from the parties, letting me know what you recommend for going forward, and what, if any, agreements you have been able to come to regarding the facts on Monday, July 12th. And then set a status hearing on Monday, July 19th at 10. Will that work for the parties?
It works. That works for
Works for
OPC.
staff.
Yes. Yes. So I'm sorry, Your Honor. Can you repeat what is expected in the July 12th filing?
I'd like to see what, if any, stipulations of fact you have regarding the MTSA issues.
Okay.
And I'd like to see what procedural schedule you would suggest going forward.
Thank you.
And then I want a little bit of time to digest that before we have a hearing on the procedural schedule. So I'm giving myself a week. Plus, I'll have just come back from
Certainly.
vacation. So
Certainly, Your Honor.
it's the paper trail on this case can at times be difficult, starting with several different complaints, and then now that the issues are narrowed down to the MTSA issues, looking at which complaints we're now talking about and what the parties' positions are on those complaints. So I just want to make sure that I have a clear path forward with the breadth of what we're going to be going forward on the MTSA issues. That makes sense. Okay. What, if anything else do we need to take up this morning? Any parties have any motions, or is there anything else that we need to take up?
I don't think so.
No.
Okay. So all that remains is, I guess I've assigned a lot of homework. Bench data request 1, which is the calculation. I'd like to take a look at that before I get an order out on this case. And then the parties to continue to work together as well as you have been. Thank you so much for all your hard work on so that we can get the MTSA hearings scheduled. And with that, thank you very much. I really appreciate all the work you've done.
Thank you, Your Honor.
Thank you, Your Honor.
We can go off the record.
Are we off the record? So, Catherine, you win the best room award. So, especially with the wet bar there.
Yeah, that's a little embarrassing, but thank you. This is my office, kitchen, living room, bar. Gets a lot done here.
Excellent. All right. Well, thanks everyone. Glad we could reach this agreement. We'll keep plowing forward and take a look at your schedules, Peter and Philip, and if you guys want to put together a call to talk about the stipulations, we can do that. We did a draft, but I don't know how you guys feel about the draft that we did, so we can talk about it. Okay.
Certainly.
All right. Thanks, everybody.
Thanks. Have a good afternoon.
Yep. You guys too. Bye.